Hello everyone, I'm Dwight Mitchell, the founder of Family Preservation Foundation, and welcome to our Child Protection Services Pro Se Help Kit video series. I successfully defended myself pro se in Minnesota and got my case dismissed and my children returned. And I will be passing on the benefit of my knowledge and lessons learned while cross-referencing Minnesota state statutes and case law, which is readily available on Google Scholar. Now, this is going to be a detailed training section. And when I say session, it's broken up into units. I'll go over the index with you in a minute. It's very detailed. I put together PowerPoint presentations for each unit. There's going to be approximately 20 or 30 or more. It goes all the way from the initial CHIPS petition all the way to a termination of parental rights and on to an appeal. So depending on where you are in this timeline of CPS, I hope to have something that's available for everyone. As I said, it's a pro se help kit. So in saying that, I need to make this one disclaimer. I need to advise you that I am not an attorney. I'm not licensed to practice law, nor am I providing legal services. You know, I've done a lot of reading and filed a lot of my own motions. I've written a lot of different things myself, but as I said, I'm not an attorney, and I recommend you to obtain your own attorney if possible and review my series titled Working with Your Attorney to get a better understanding of what you need to go through in order to be successful in this educational series. My goal is to help you become more informed so that you can make informed decisions. You got to remember, you can't say just give it to the attorney and say go do this. No, it's up to you to win your case, and you have to work with your attorney. You know the facts, the attorney knows the law. If the attorney says something, you say fine, show me the statutes or show me the case law. Why are you doing it this way? And if your attorney is giving you a hard time and says you just have to trust me or you just have to believe that I know what I'm doing, no, you don't. The attorney works for you. Whether you're paying the attorney or the attorney is the public defender, and that attorney needs to make you understand everything, because everything is going to affect you. It's not going to affect that attorney. It's you and your family, you and your children, so that you need to understand everything. And so I'm trying to educate you so that you can make informed decisions, so that if CPS is saying something to you, or the judge is saying something to you, or the attorney, or the public defender, or whoever, you have a thorough understanding of what they're saying and whether they're telling you the truth or they're not telling you the truth. With that in mind, this educational series will be going through everything from beginning to end. So it's going to help you in your defense, in your fight against CPS and protecting your constitutional rights. This is going to be hard work. Make no mistake. Nothing in this world, that's comes free. Nothing worthwhile comes free. We all know that you have to work hard, and hard work brings about a reward and a success and satisfaction. So even if things don't go your way, you went down swinging and fighting. The Minnesota templates I will provide are examples only. They are not templates that you can actually use and submit to the court, because every single court case is different. Everything has different facts. I'm going to give you a couple of examples. You're going to have to fill out the whole document, that I have available. I don't have a template for everything. Some of the things can be found online. A lot of the things I do is I will go online and I'll search for whatever it is I'm looking for, like motion to dismiss, Minnesota, and then child protection, and I'll look at others that have been filed, and then I'll look at them and say, okay, I need to do it like this, and I'll look at the heading and the body, and then I'll write mine up accordingly. So you're going to have to do that also. You're acting pro se, so you must create your own court filings, and everything you do, you're doing for yourself. Remember, you can't go into court and say, somebody told me to do this, or I'm doing this, or I'm doing that. That's not what pro se means. Pro se means you're doing it for yourself. So if you don't understand it and you let somebody tell you something and you do it, well, shame on you. So that's not what we're doing. We're not giving you legal advice. We're giving you an educational class. So these are training units. There's a number of different training units. I started about 20, and I've had to break some of them up because they're rather long. But in saying that, I'm telling you where to go get information, based upon what's going on, and where to seek, information, and how to put together documents. Like when I go over the timeline, I'm going to be going over the CHIPS timeline, in detail. And I'm going to actually be showing you the statute. So the timeline actually has a reference. It's going to say this happens here, and here's the state statute for that timeline. So as you go along, and as I go along the series talking about the CHIPS to permanency timeline, I'm going to cross-reference all the state statutes, and then I'm going to give you a listing of all the recent case law that has come about within the last couple of years as it relates to child protection. There's tons of case law and cases on child protection on Google Scholar, and you can actually sort it by year, but you just go in, you can filter on state and say, give me Minnesota, and say, I only want to see Minnesota state court law, and you can look at everything that's out there. But you need to do this for yourself. You must read, and it's a lot of reading. And you're not going to get it right away. No one gets it right away. It's going to take you a little bit of time, as I said earlier, but I'm confident you can do it. And remember, you're fighting for your family, and you're fighting for your children. So an index of some of the sections. One of the first sections is Know Your Rights and what to do if CPS comes knocking at your door. Then it's going to be if CPS opens up an investigation with you. As I told you earlier, another one is working with your attorney. That's broken up into multiple sections because there's so many different caveats or different reasons that you're brought into child protection. It could be corporal punishment, it could be neglect, it could be drugs. So all of these things are discussed in detail from an educational perspective, like what are your rights, what you can and can't do, and how, not to allow CPS or even the court system to bully you into something. So if you're educated and you understand the law and they know you understand the law, well, then they can't make you do something that's illegal, because then you can call them on it, right there in court. So one of the key things I go over is CPS 101, child removals from the home to CHIPS permanency timeline. That is critical, and everyone needs to understand that timeline. And within that timeline, I'm going to break down the various units of what needs to happen. So when we're talking about the emergency protective hearing, I have a unit on that, and I'm like, here's what you can do, here's what needs to happen, here's how you defend yourself if you don't have an attorney, or if you do have an attorney, here's what you and the attorney should be working on. I'm going to go over the emergency protective hearing. I'm going to go over the admit-deny hearing, the out-of-home placement plan, and exactly when you have to adhere to the out-of-home placement plan. Most people think that they have to do it right away. You are not required to do anything on that out-of-home placement plan until after you have had your trial in 60 days and you have been found guilty of abusing your child or child abuse. Don't let anyone tell you differently. Don't let CPS say, well, if you start working on the plan now, we'll give you your child back, or you'll get your child back sooner. That is a flat-out lie. The truth of the matter is, in Minnesota, they have to give you a trial in 60 days, and they have to prove what's wrong, prove that you're guilty, and then and only then can the judge order you to do that plan. Prior to that, you do not have to do that plan, and I will show you that and the statutes relating to that. Next, I'm going to go over the pretrial hearing and how to prepare for that and what you should be looking at and what you should be doing. I'm going to actually go over the CHIPS trial. That section is rather large. I'm going to probably have to break that up into a number of different PowerPoints. We're going to have to talk about preparation, witnesses, how to collect the evidence, what you need to get together. So that CHIPS trial section, it's probably going to be a number of different videos, and it's probably going to be a little bit longer. We're going to talk about findings. If the judge does find in favor of CPS and adjudicates your child as a CHIPS child or in need of protection or custody, and then what you have to do after that, with the disposition. We're going to talk about review hearings and what to do in these review hearings that happen every 60 to 90 days. We're going to talk about permanency pleadings. If the county wants to try and terminate your parental rights or that's filed, then I'm going to talk about the case law. And what most people don't realize is that's a very, very difficult case for CPS to prove. The reason CPS gets away with it because most parents, as I said, about 5,000 a year go through this whole proceeding, and CPS just runs roughshod over the parents, and the parents don't know how to defend themselves. So I'm going to go over that in great detail, so that you know what the Eighth Circuit says and what they have to prove and what you can say to the judge and how you can call both CPS and the judge out as it relates to terminating your parental rights. If a petition is filed for termination of parental rights, here again, there's another admit-deny hearing for that permanency. There's a trial that's going to happen, so there's a permanency trial that takes place that we have to, prepare for. There's a permanency order by the court, and then there's post-trial motions that we're going to go over and what you can do. One of the first things you should do is file a notice of appeal, and we're going to go over how to file an appeal. And if you're successful in getting your case thrown out, we can talk about, filing a federal civil rights lawsuit if you feel that the CPS violated your constitutional rights. I will also have a PDF presentation for each lesson available for download. So you'll have a hard copy if you want to download the PDF first and then read along with me so you'll understand and make notes on the PDF. I think that will be good. Of course, you'll need a computer and a printer to print out the PDF. So go to Kinko's or something of that nature, or the library to print out the PDF. I recommend that you download it and read it several times until you understand everything. You can only ask questions in the group. It's a closed group, so only people in the group will see the questions, and there are no dumb questions. People can help you, understand. So members can respond to questions, and that is the whole purpose of the group in the forum. If there's anything posted as it relates to some story about a social worker or anything that's not specifically related to defense, please put that on the Stop CPS from Illegally Kidnapping Children group page. That's a public forum, and that's where you post all of those things. If you violate, this too many times and you're posting things or trying to post a political agenda or anything, I'm going to, take you out of the group. As I said, this is an educational group only, and it's for helping parents, protect their constitutional rights and help get their children back. So if you do give an answer to someone on the website to a question, you must have a state statute. You can't say, well, I think this happened, or, oh, with me, it was so-and-so. Please don't give an answer unless you have state statutes or case law, or if you have a document. They say, well, you can scan in your document and upload yours and say, well, hey, here's my document. Let me give it to you as an example. You can do something of that nature. I don't have any issues with that. Just keep it, this whole group is about helping parents put together a defense against CPS. So, once again, anything not related to learning and training can be discussed on the Stop CPS from Illegally Kidnapping group page. That's an open group, and so you can discuss everything not related to education and defense there. In closing, I'd like to say one thing, and I'll leave you with one major piece of advice. Do not believe anything anyone tells you unless there's a Minnesota state statute or case law accompanied with it and you've read it yourself. You read it and you understand it. Ask questions so you do understand it, and make sure that the case law isn't superseded. If someone gives you a case law from 2000, immediately go search to see if it's called shepherding, to see if that case law has been re-argued more recently. So always look to see if there's, the most recent case law on any topic you're going against. I'm going to be submitting about 2 or 3 pages of recent case law within the last 2 or 3 years as it relates to Minnesota CPS. So you'll be able to look at the case law and read and understand how this impacts, your case and what you're doing. Make the CPS workers, the state and county officials, the judges, make them show you the relevant statutes that they're referring to, just as I will throughout this entire educational series. Do not ever take anything they tell you for granted. If they say, well, that's the law, what's the state statute? Show me the statute. Show me what you're talking about. And only then do you take it under a grain of salt until you go reference the case law. The statute might say one thing, but it's how it's been applied with the case law. And so those are some of the things we're talking about, and I hope you get a lot out of this educational series. The PDF tells you how to join the group. You have to be a member of FPF. So the very first thing you have to do is become a member of Family Preservation Foundation. And the PDF shows you how to do that. And then, once you are a member and you supply your case number and we validate that you have a valid case, then we'll allow you into the group and we'll send you an email so you can get started with the educational series. Thank you very much. I hope I was able to shed some light on our new CPS Pro Se video help kit, and that you'll find it very educational and informative. Good luck in your fight. Thank you very much.